We are following breaking news. The Colorado Supreme Court has ruled that former President Donald Trump will be left off the state's primary and presidential ballots. The former president could appeal it to the U.S. Supreme Court and almost certainly will. Trump's candidacy was challenged by invoking the 14th Amendment's disqualification clause. It states that anyone engaging in insurrection cannot hold public office. That, of course, refers to his actions on and before January 6th. CBS News Chief Washington correspondent Major Garrett joins us now. Major, what's your first reaction to the ruling?
That this is an important moment for Colorado and quite possibly, John, an important moment for the nation. The Colorado Supreme Court was asked to answer a never-before-asked question in our entire history. Could the actions of a president blocking the peaceful transfer of power and setting in motion a violent effort to resist that peaceful transfer of power be, according to a court, deemed an insurrectionist? And if so, therefore disqualified from ever appearing on that state's ballot again? That's the central question. And the Colorado Supreme Court has said the answer to that is yes, that the behavior of the former president, while he was president of the United States, attempting with a crowd, going to the Capitol and interfering with the certification of electoral votes, was acting as an insurrectionist in an anti-constitutional way. This is appealable, as you said, John, and it most certainly will be appealed. But we have a great deal of murkiness around this central question because it's never been asked before. And this falls into the broad category of where we find our law and politics in America today. Would we be asking these questions if but for Trump? And in this question, the answer is no, because we've never asked this question before. We've never had to even imagine what an answer to this question would be. But we do now, and one state, other states have either bypassed this or sort of left it in abeyance where this question has been raised, but the Colorado Supreme Court has not. It has rendered an opinion on this matter and on this question.
And we now have a Trump campaign statement that is that goes on at some length. I'll just read a little bit of the beginning of it. Unsurprisingly, it reads, "The all-Democrat appointed Colorado Supreme Court has ruled against President Trump supporting Osora," and then it goes on. So obviously President Trump and his campaign, former President Trump and his campaign are going to push back against this. How do you imagine this plays out, Major? I mean, the response from the Trump camp is the one you would expect. Do you think this creates a dynamic other Republican lawmakers have to weigh in on this? Obviously, there's a legal element. How do you think this might play out?
Well, so many Republicans will come to the president's defense and say this is not a matter for the courts or secretaries of states to decide. The primary should decide who the Republican nominee is, and the voters should decide whether or not former President Trump's behavior was like that of an insurrectionist. And this is a sort of interposing, a judicial interpositioning between voters and a potential nominee seeking the highest office in the land. The litigants in this case were not Democrats, by the way, John. They were Republicans who wanted this question asked and answered for the state of Colorado. And one of the interesting constitutional questions here is, what does the Constitution say about state power to conduct elections? It's very clear, John, and you know it. The Constitution says states will decide time, manner, and place and will adjudicate differences or discrepancies or controversies that arise within their state. Well, that's what Colorado is doing. And it's not clear that the federal Constitution gives the Supreme Court the right to say in time, manner, and place or resolving disputes or discrepancies, the Supreme Court can overrule a Supreme Court. Again, we are in uncharted land. But for Trump, we would not be here. These questions wouldn't even be asked, but they have to be asked, at least in the case of these litigants who brought the case to Colorado. And the Supreme Court has now said, you know what? That behavior is inconsistent with the Constitution. It qualifies under our reading of Section 3 of the 14th Amendment. And what does that amendment and its section say? You must be disqualified if you act in a way that can be fairly and legally ascertained to be insurrectionist. That's what they said. Yeah. As I said, Other states have looked at this and not reached the same conclusion. So this is by no means universal. But the politics of it will be a court is interfering. There will be a partisan cast applied by former President Trump. But remember, the litigants are Republicans, not Democrats. And this question cannot be dismissed as immaterial. The conduct of President Trump as president of the United States on January 6th, whether legally or not, however that's resolved in the courts, will be front and center politically in the 2024 election. And whatever the Trump campaign wants to believe about that or not, it's not a net positive.
Do you think in any way, Major, this would recenter the question of his role leading up to, in the months leading up to January 6th and on January 6th itself? And this is what I mean. So Kevin McCarthy, the former House Speaker, shortly after January 6th, said that Donald Trump was responsible for the attack on the Capitol. He further said that it was his responsibility to bind up the wounds, to steal a phrase from another era. In the wake of that attack, Trump did neither of those two things. Those would render a verdict on the question of whether he was responsible for the insurrection. Well, Kevin McCarthy has changed his mind, and he's now endorsed Trump. But what I wonder is, Major, whether this returns to not a legal question, but a simple moral one. If you are supporting the president, are you supporting somebody who supported an insurrection? And is that consistent with the office he's trying to be reelected to?
Right. Most Republicans don't want to answer that question, John. They just don't, because they know the moral terrain on which that question stands is very fragile for them. Because you can't look at January 6th and say former President Trump's actions were neutral. They weren't neutral. They were aggressive in a direction to try to block certification and then gum up the works and cling to power. And as others who participated with the former president, who was president at the time, are brought to the bar of justice in Georgia, some of his attorneys have already pled guilty. Rudy Giuliani very recently was found civilly liable for defamation about what he said about what people did in connection to that election in Fulton County, Georgia. Accountability is happening. It was a defamation case against Fox News. When these questions about the 2020 election are put into the court of law, and they must be measured, not by rhetoric or not by political campaigning or rallying, but by facts and law and process, they lose and lose again and again and again. And it takes a long time for that process to play out, but it is playing out over and over and over again, and the results keep being the same. The liars, those who told falsehoods intentionally and with malice about the 2020 election, are being held to account. And this question has now reached the highest level of this nominating contest for the Republican Party. And it will have to render a verdict on whether or not the former president, then President Trump's actions are morally consistent with the future of the Republican Party. So far, the answer is yes, I guess so, because he's the leader in Iowa, New Hampshire, everyone else. But there may come a time when the attitude and the answer to that question may shift.
Major Garrett with us from Washington. Thank you so much, Major.
Thanks.
CBS News election law contributor David Becker joins us now. David, this ruling, help us understand what the court found and where it ties into the Constitution.
Yeah, Major's quite right. This is unprecedented and in many ways unexpected. Every other court that has looked at this issue has decided not on the merits. They didn't rule that Donald Trump didn't engage in an insurrection, but they decided based on procedural grounds like standing or ripeness, meaning that because he was just running for the Republican nomination and the Republican Party has a great deal of latitude in how it decides its nominees, that it wouldn't be right for them to rule on whether or not he could appear on the Republican primary ballot. In Colorado, the cases actually took a different path. The lower court actually found as a legal and factual matter that Donald Trump's actions in inciting the mob to go to the Capitol on January 6th, quote unquote, were engaging in insurrection under the 14th Amendment. But they didn't disqualify him because they found that in the lower court that the office of the presidency wasn't an office of the United States under the 14th Amendment. Most legal scholars, including myself, felt that ruling was not going to stand on appeal, and in fact, it didn't. And what the Colorado Supreme Court found today was that this matter was ripe, that Colorado state law says that only someone qualified can appear on the ballot, and that the presidency was an office of the United States under the 14th Amendment, and that Donald Trump engaged in insurrection and therefore could not appear on the ballot. This is a very important decision. We've never been here before. And I think this Colorado Supreme Court, recognizing that, stayed their own decision until January 4th of next year, giving the Trump campaign an opportunity to appeal to the United States Supreme Court, which I think is almost certain. And then the United States Supreme Court could decide on whether to take it. It is not mandatory that they take this case up. But I think almost everybody, including myself, thinks that it's almost a 100% likelihood that they will take on this case.
So, David, you outlined, I think, if I've got my math right here, 3 tests. Let me take them in order. In terms of the merits, I just want to grab a hold of what you were saying about the parties. So essentially, the other states ruled, and I'll paraphrase it and you pick it apart, ruled essentially that because parties, political parties, make up their own rules, the Constitution doesn't govern them. The Constitution governs elections for federal offices, but how the parties choose to pick their people, that's their own deal. Is that essentially what the other states decided?
Yeah, that's exactly right, John. There's a First Amendment protection for parties and others to engage in a right of association. And here, the political parties, the Republican Party in this case, has a right to decide who's going to represent them in the presidency. So what Donald Trump was running for, at least as determined by these other states, wasn't for the presidency, but for the nomination to appear on the ballot for the presidency in the general election. So it wasn't quite yet ripe for the court to take this on until after he was officially the nominee. Colorado decided otherwise.
So now help me through with this. The presidency is not an office of the United States, because that has always, to me, been a head scratcher.
Yeah, and I think it was to most of us who looked at the lower court decision. I mean, if you think about it, the office of the United States certainly encompasses especially the presidency. When the 14th Amendment was drafted in the aftermath of the Civil War, can you imagine that the drafters of the 14th Amendment sought to exclude the presidency, sought to allow Jefferson Davis or Robert E. Lee to take the Oval Office in an election? I think that's certainly not the case based on all the legislative history and all of the plain language of the 14th Amendment. So it's not surprising that the Colorado Supreme Court ruled that the presidency was in fact covered as an office of the United States under the 14th Amendment.
And then finally, on the question of insurrection, obviously the leaders of former President Trump's party in the House, the Senate, his own vice president, have all said he was responsible for the insurrection. But what's the legal test for that question?
You know, we've never really fleshed a lot of this issue out. What we know is it doesn't mean that someone has to be convicted of sedition or insurrection. The terms engaged in insurrection is used in the 14th Amendment, not convicted, not found by a court. And we're going to take that language as it is in the 14th Amendment. So it becomes a very complex factual matter and legal matter to determine whether or not the actions of the former president, with all of his inflammatory language, with encouraging the mob to go to the Capitol on January 6th, after the election had already been determined, after all of his legal cases had failed, including before Republican judges as well as Democratic judges. And so that is likely where the appeal is going to center when it goes to the United States Supreme Court. And as I said, I think they're likely to hear it.
And so you mean you think it's likely to center on whether he had a causal relationship with the attack on the Capitol? That it's that question?
Yeah, and they'll parse the meaning of the words insurrection and engage and whether he engaged in insurrection. And of course, there will be other legal arguments. We will continue to see the argument about whether the presidency is an office of the United States. That is not a unanimous opinion amongst legal scholars, although the weight of most believe that that it is an office of the United States. And this ripeness issue is likely to still come up. I mean, that is theoretically, though, a Colorado state law issue, right? And that was Colorado state law ruling, and it may be something that is outside of the purview of the United States Supreme Court, which can only take up federal and constitutional issues.
David Becker, CBS News election law contributor and expert, thank you so much for helping us sort through this, David. We appreciate it.